insurance company. Now, Tom is going to, I think he's going to wear two hats. He's going to help us overcome that defense and also help those people acting for insurers maintain the defense. Tom McGrenere.
I think with great respect that our chairman has expectations beyond which I can deliver. Being a primarily defense counsel, I must tell you that there are no defenses to misrepresentation cases. And he's quite right. He picked the topic, and I can tell you that it is not a scintillating topic by any stretch of the imagination. My one partner, who is perhaps better known for his honesty than his diplomacy, asked me what I was speaking on, and I told him misrepresentation. And he said, my goodness, he says, I can't think of a duller topic. And he says, as a matter of fact, yes, I can. He says, I can think of something that would be a little duller, and that would be you delivering a talk on misrepresentation. Now, hardly that is the type of comment that will instill confidence in you, but notwithstanding that, I will attempt to go over this in part. And I should acknowledge Mr. Justice Montgomery, who's now with us at the back of the room, who indicated that if I went anywhere beyond 20 minutes, he would ensure that a hook came out. I may now be confined to about 10 because of the time. The purpose of the paper, and I must acknowledge that the paper that is in your books today is primarily done by a very valued student in our office, Ray Watt. And it's been a learning experience as I go through this with you. But the purpose of the paper was primarily to indicate to you a measure of pre-contractual arrangements. And I'm stopping because I hadn't included page 1, which may be helpful. And I intend to deal with only the pre-policy misrepresentations. The others will be dealt with later. And I intend to examine very briefly the legislation and the court considerations of the insured's and the insurer's obligation before entering into a contract of insurance. And I want to do this in the general categories of the general insurance, fire, automobile, accident and sickness, and marine. I frankly don't intend to spend much time on the marine. And as I say, it's pre-policy breaches only, and it's important to note that you start with the principle that insurance contracts are different from ordinary contracts in that they include and are based upon the term of uber me fide. And I think since this is an important feature and it comes up in the consideration of the statutory provisions, that I should give you the definition of Jowett's Dictionary of English Law definition, that is. Of course, most of you are much closer to law school than I am, but for the most part, with the odd exception of these cases, I don't run into uber me fide very much. But uber me fide is defined as of the fullest confidence, of the utmost good faith. A contract is said to be uber me fide when the promisee is bound to communicate to the promisor every fact and circumstance which may influence him in deciding whether to enter into the contract or not. Contracts which require uber me fide are those entered into between persons in a particular relationship as guardian and ward, solicitor and client, insurer and insured. And the Carter case, which is in your material, really deals with the general common law principle, and it states that the insured is obliged to make full disclosure of all facts pertaining to the risk. And a simple mistake, that's leaving aside fraudulent intention, can void the policy if the insurer is deceived. So there's the connection. Simple mistake, if the insurer is deceived, it doesn't make any difference as to the intention of the insured. The policy is voidable. Now, the statutory provisions in dealing with these categories that I'm speaking to you about are a little bit different, and it's interesting that each provision that deals with each general area, i.e. the general, fire, automobiles, and accident, are all just a little bit different. And I'd like to deal firstly with the general insurance policy, such as your general commercial liability policy or comprehensive liability policy. And Section 104 there indicates that the application is not a part of the contract unless the court determines that it contains a material misrepresentation which induced the insurer to enter into the contract. So that the application doesn't get before the court unless that is a particular term. It also provides that under Section 101 that no contract can be avoided by reason of any inaccuracy in an application unless it is material to the contract. It stipulates that these provisions, these provisions as to general insurance, do not apply to fire or auto policies, and we'll deal with that in a moment. But it's important to note that insofar as general insurance is concerned, the misrepresentation must be material and it must be misleading. It's not essential that it be fraudulent. And insofar as materiality is concerned, Section 101 of the Insurance Act says that this is a question of fact, and the test is set out in the Ontario Metals case, which is in the material, and Lord Salvinson said that it is a question of fact in each case whether if the matters concealed or misrepresented had been truly disclosed, they would, on a fair consideration of the evidence, have influenced a reasonable insurer to decline the risk or to have stipulated for a higher premium. It's a common sense approach, really. It's important to note that the fact that the misrepresentation, though, was totally innocent is irrelevant. The policy can still be avoided if it misleads the insurer. And from the insurer's standpoint, again, it's important to note that the insured is presumed by the courts to be acting in good faith, and any ambiguity in the form of contract is to be construed against the insurer, unless, of course, it's a statutory condition, and you don't run into those too often in the general type of insurance policy. I'd like then to deal with the category of fire insurance, and in this instance the application need not even be in writing. But there's an interesting section, in Section 123, that says that if the application is in writing and the insurer issues the policy, that policy is deemed to comply or be in accordance with the application unless the insurer, and the onus is on the insurer, to stipulate to the insured that it does not cover what was applied for in writing. And there is a different test when you start dealing with the statutory requirements under the fire insurance policies as to misrepresentation. And firstly, it's important to note that the statute gives greater protection to the insured than does the common law or that is afforded under the general insurance provisions. Section 125 says that the contract must contain the statutory conditions and that no variation or omission or addition is binding on the assured. Now, statutory condition 1 outlines the responsibilities of the insured regarding misrepresentation. And in this respect, the insured must first falsely describe the property to the prejudice of the insurer, or secondly, misrepresent a material fact, or thirdly, fraudulently omit a material fact. Now, again, I point out to you that the misrepresentation need not be fraudulent. It can be a simple and an innocent misrepresentation, but you cannot falsely describe the property to the prejudice of the insurer, nor can you fraudulently omit a material fact. And frankly, from looking at some of the cases, and I don't propose to go into them now, and nor do I think they're set out to any great extent in the material, it is very difficult to see a misrepresentation, an innocent misrepresentation where the policy has been avoided that could not easily have been construed as a fraudulent omission without the judge having to torture the facts too much. The meaning of fraudulent omission is in the material, and it's described in one of the cases as an actual fraud. It must be it must be a situation where the insured actively withholds material facts. And it is on the onus is on the insurer to prove fraud, and the insurer must first prove that A, it's a material omission, and B, that the insured actively withheld it. So that as you move from the general to the fire, you can see that there's a greater onus upon the insurer in trying to set aside the policy or void the policy on the basis of misrepresentation. The omission must be material, and it must be demonstrated that it was actively withheld by the insured. There's a case that's in the material. It's the Chernier case, a decision of Justice Galligan, where the applicant stated falsely, and he so found that this was false, that, and she was insuring a hotel, I believe it was, that firstly that no other insurer had declined the risk, when it was not true, and secondly that no other insurance company had canceled her policy, which was not true. But notwithstanding that, the judge found that there was no evidence of intention to deceive. Well, I think from reading that, it's important to take from that that the judge can look to the mind of the insured and introduces then a subjective flavor, what was in the mind of the insured when the insured put in this application. Again, on a quick reading of it, it would appear that Justice Galligan may have been a little generous to the plaintiff. In any event, he did highlight the two main considerations that go into the insurer taking a risk in the fire policy. In fact, it's in pretty much all insurance, but certainly in the fire risks, it's firstly the physical state of the property, and secondly, the insured person, i.e. the moral risk was this person in a situation where the fire was a handy solution to financial difficulties. And for that, you should see the Goldschlager and Royal Insurance case, which is in the file, where the applicant seemed to have a slight lapse in memory or suffered from advanced senility when she said she didn't have any encumbrances on her property. And when it went to trial, I think they found something like 7. In any event, the state of mind of the person must be taken into consideration, as Justice Galligan would suggest, as well as the physical property. And the morality question arises throughout all of these considerations whenever you're dealing with the person who puts the application in. I'd like then to go on briefly to the automobile aspect. And here, again, the complexion changes somewhat because the application forms part of the policy here. It's stipulated right in the standard form policy, which is a government form. It's an agreed upon form by all the insurers, and it's introduced by the superintendent. And it becomes, right from day one, part of the policy. It's a standard form both as to the application and as to the policy, and this to a great extent is for the protection of the insured. And I should pause to mention here, and it's not in the material anywhere, but the insurer is not under any obligation to send an insured a policy. Quite often when misrepresentation cases come up in the automobile field, the solicitor, perhaps a little bit inexperienced, says, well, my client didn't get a copy of the policy. Well, they're not obliged to give a copy of the policy. I think it's under 204, one of those sections, which says that because it's a standard form, they can just simply give a certificate and make reference to the fact on the back of the certificate there's a variety of coverages that are available. And if you want a policy, you, of course, can ask for one. In any event, the standard policy establishes a common framework so that the applicants are not subjected to onerous questions in the application that may affect avoiding of the claim. In this respect, I want to deal just briefly with Section 206, where it says that an applicant for a contract, or where an applicant for a contract gives false particulars of the described automobile to be insured to the prejudice of the insurer, or knowingly misrepresents or fails to disclose in the application any fact required to be stated therein, a claim by the insured is invalid and the right of the insured to recover indemnity is forfeited. Well, the emphasis here is that the assured must give false particulars that relate to the automobile described, and secondly, act to the prejudice of the insurer. So the onus then is on the insurer to demonstrate that the false particulars were prejudicial in some fashion to the insurer. The misrepresentation must be knowingly, and I put that in quotes, and it must be knowingly done by the applicant. But the interesting feature here is that where the misrepresentation is knowingly done by the applicant, the cases seem to suggest that the insurer does not have to show prejudice at that point. All it has to do is show that the misrepresentation was knowingly done. In that respect, there's a case that's in the material, a Slay and Stevenson case, where the mother was the registered owner of the vehicle when in fact the son was a true owner. She had filled in the application and denied reading the application before signing it, and the court really found that it didn't make any difference, that she knowingly misrepresented these facts because it was implied from the fact that she had signed this form that she knew what was in it. And Justice Kellogg in the Court of Appeal commented on the word knowingly as thus: I think knowingly in the statute is used in the sense that the applicant is in possession of information that what is in fact stated in the application is untrue or does not disclose the truth. Again, one would think a very common sense approach. And as I say, since the appellant had signed the application, the mother in this instance, it was presumed that she knew what was contained in the application and thus was found knowingly to have misrepresented. And that case has been followed. It's a 1943 decision, and it's still one of the leading cases. Off point, perhaps, of vitiating the policy per se, insofar as the insured is concerned, or voiding the policy, you should know that the auto policy has a rather unique provision in it. Those of you who do a lot of this work will be quite familiar with this. Those who are not into this line of work very much may not appreciate that in the auto policy, the mere fact that the insured has done a variety of things either before the issuance of the policy or after the issuance of the policy does not necessarily, in fact does not at all, in most instances, mean that the policy is voided as against the third party. In the instance where I hit our chairman as a pedestrian and leave him paraplegic, and my policy limits are at stake, and I have lied repeatedly in my application, and besides that I was drunk and I was running from some crime at the time, and there was a multitude of things whereby my policy was voidable, and my coverage was invalid. That does not interfere with his right, after getting judgment against me for my limits, to go after my insurer directly. And this is a unique provision under the auto portion of the policy. And Section 226 there provides that any act or default by the insured before or after entering into the contract and any contravention of the criminal code or other statute does not avoid the policy insofar as third-party rights are concerned. Now, I may have misled you there very briefly by saying he could go after my limits. If, in fact, I've done all of those heinous things that I've told you I did, he would only be entitled to the minimum limits, which would be $200,000 at this time, notwithstanding that I may well have a policy that's worth $1 million. So that there is that stipulation, and his claim would be confined in that regard. I'm running dangerously close to the hook. I want to deal then very briefly with accident and sickness. And in this respect, the onus is on the applicant to disclose every fact within the knowledge, within his knowledge or her knowledge that is material. And this is Section 261 of the provisions. And the failure to disclose or to misrepresent, as in the other provisions, makes the policy voidable. But it's important to note here that the insurer's defense must be based on a written statement, whether it be the application form, a medical examination report, or a written statement or answers given by the insured. And that changes the complexion a little bit from, again, the general insurance and the fire insurance. It's fairly similar to the auto, except that here you don't necessarily have to have a standard application. In fact, you don't. And in this instance, I should note the decision of Johnson and Eaton Bay. You should look at that because in that situation, the applicant had a high blood pressure problem in 1976 when she had first applied for the insurance. The insurance lapsed because she missed the payment of the premium in April of 1977. When she finally caught up with paying it, the policy was reinstated in September the 17th, 1977. But they found out she had failed to disclose the high blood pressure, which had existed, by the way, for 7 years up till that time. She died September the 7th, 1979. I stress this date because I'm going to make the point that turns on another section in a moment. And the Court of Appeal held that notwithstanding that she had made a bona fide application and that she was mistaken as to the belief as to this being a material matter, the policy was voidable. Well, now, if this claimant had lived another 10 or 11 days, this would not have been a problem because Section 262 would have kicked in, which provides that where a policy has been in existence for over 2 years, then the misrepresentation in the absence of fraud has no bearing on it. So very simply put, in life and sickness and accident policies, if your assured can get over the 2 years, she can forget or he can forget about the misrepresentations, save and except for fraud. That would, of course, always apply. The other aspect about that you should perhaps be mindful of is the age factor when someone is applying for life insurance. Age, a misstatement of age doesn't void the policy. All it does is allow the option, unless it's a wholly misleading or a fraudulent misstatement, but it allows the insurer has the option to either give a lesser coverage or charge a lesser premium. And similarly, the provisions that I spoke to you about insofar as misrepresentations in an application, the fact that a person has a prior sickness or illness will not come into effect if the policy has existed for 2 years, even if that person has failed to disclose that. This is set out in some detail in the material, as is the marine, and since most of us don't involve ourselves on a daily basis in the marine, I don't intend to go into that. Very quickly, in summary, I want to say that the majority of clients arrive at your door after the problems have arisen. And unfortunately, the damage often is done at that point, and the remedy is either non-existent or very difficult. If you have the opportunity and you're consulted in a general way, you should try to assist your clients by reviewing their policies with them. And if you are uncomfortable with your ability to tell the person whether or not the coverage is appropriate, then you should either assist them in seeking the advice of a good agent or broker or direct them to one. In closing, I want to say that the paper should have had in a bibliography a reference to a text by J. Menezes and Craig Brown, Insurance Law in Canada, 1982 Carswell report, or text rather. I am told that it is a leading case in insurance law in Canada. In fact, I'm told it is the only one, so it has that distinct advantage. Unless there are some questions, that concludes my presentation.
Well, it seems that everybody's anxious to go for lunch. Thank you very much, Tom. We appreciate it.
It's a production of Carswell, 1982, but it's J. Menzies, M-E-N-E-Z-E-S, and Craig Brown. Menzies is a prof at Windsor, I believe, and Craig Brown at Western. I may have them reversed.
Thank you again, Tom. Very pleased to have with us Mr. Justice Montgomery. I've asked Mr. Justice Montgomery to deal with a very interesting topic of mention of insurance, the judicial perspective. What we're going to do is change the program slightly for this afternoon. Mr. Justice Montgomery is going to say a few words, and then he's going to be followed by Mr. Goudie. And then after that, we're going to have the panel review with Messrs. McGrenere, Goudie, and Mr. Justice Montgomery. So would you save your questions, any questions arising from Mr. Justice Montgomery's address and Mr. Goudie's address for the panel, please. Mr. Justice Montgomery.
This topic is fraudulent. I'm here under false pretenses. It's a nothing topic. Mr. Papazian inveigled me into dealing with it just to get me on the panel so that I could be put on the hot seat. I'll tell you that I will be brief enough on this topic that you won't even have time to settle into your afternoon nap. Really, the very few cases that I have cited in the material say it all. I don't think it matters today very much whether insurance is mentioned or not. And as I have indicated, if it is inadvertently, the judge will cover it in his charge to the jury, and the case will go on. In the event that counsel raises it with the jury or deals with it in an improper fashion with a view to getting rid of the jury, the judge will deal with counsel. And I'll leave it at that. What I really want to talk to you about, and now I'm upstaging Mr. Papazian, is to deal with a topic that I wasn't assigned at all. Because in my view, these sessions usually are and ought to be bread and butter sessions. And nothing to me is more relevant to the insurance practice, indeed the entire practice before the courts, than the new rules. Now, can you imagine anything stuffier than rules of court? Well, these rules, if you've read them, you'll see, are a little different. Just how many people have read the rules? And don't be ashamed if you haven't. Most people haven't read them. Has anybody read them? Very few. Well, let me tell you what's there waiting for you. Because they're very important. You should go back to your office and get tidied up for the end of term, and then over the summer vacation, look at the rules and read them. And when you do, and particularly the ones I'm going to direct you to, I think that you're going to reassess every file in your office. And you're going to do something with that file to be ready on January the 2nd when those new rules come in. Now, if you don't, somebody is going to steal a march on you. The first rule that I think is a breath of fresh air is the provision for the production of the policies of insurance. And heretofore, we've had that great mystique about what the coverage was, what the limits were, And how many lawyers have you had say to you, look, I don't even know the limits myself. My company don't tell me what they are. Well, I will go out on a limb and say this about those insurance companies. They are not doing what they are obliged to do under the existing practice, because it is not the insurance company who's the client, it's the litigant. And the lawyer is acting, the insurance lawyer, so-called, is acting for the assured. That's his client. And he has a right to know everything about the policies. However, that problem is solved under the new rules. And Rule 30.013, sorry, 02 bracket 3 says, a party shall disclose and, if requested, produce for inspection any insurance policy under which an insurer may be liable. Now, bearing that in mind, you will turn back to the paper given by Mark Lerner and see how much homework you have to do in your examination for discovery and before examination for discovery in eliciting all the policies that may be relevant and may bear on the issue. The sub 4 says that the court may order a party to disclose all relevant documents in the possession, control, or power of the party's subsidiary or affiliated corporation, or of a corporation controlled directly or indirectly by the party, and to produce for inspection all such documents that are not privileged. Now, as a companion to that provision, the following rule deals with affidavits, affidavit of documents. And 30.03 sub 1 says, a party to an action shall, within 10 days after the close of pleadings, serve on every other party an affidavit of documents. So you don't need the old notice to produce anymore. The obligation is there to do it within that stipulated 10-day period. And all those files that are sitting in your filing cabinet now are going to be subject to these rules. And I'll briefly deal with the transitional rule in a moment. Now, the solicitor's certificate is 30.03 sub 4. Where the party is represented by a solicitor, the solicitor shall certify on the affidavit that he or she has explained to the deponent the necessity of making full disclosure of all relevant documents. Now, you'll remember in the Old English cases dealing with the responsibility of a solicitor in preparing an affidavit, that the English courts have held that in the preparation of affidavits on production, that the solicitor is the conscience of his client. And there have been cases of disbarment where the solicitor has not been as astute as he ought to have been to see that the relevant productions are made, so that bearing the English jurisprudence as a backdrop for that rule, there's some teeth in it. Now let's go to the second exercise of what you're going to do in the summer, and that's the part dealing with settlement. You're not going to have payment into court as we presently have it, but there is a provision for an offer to be made by the plaintiff, and there's a provision for an offer to be made by the defendant. The form of that offer is prescribed in the rules. The rule dealing with offer is Rule 49. Now read it carefully, because it can be a very useful tool in your arsenal. You serve the appropriate form of offer pursuant to Rule 49, and suppose you do it at the time you issue your statement of claim, and you say, I'll settle for $50,000. The defendant may snap you up on that and settle it, and it's done right then and there. Conversely, the defendant may say this case is worth $10,000, and somewhere down the line, the defendant may file an offer and offer you $10,000. If you succeed in getting more than the amount that you've offered to settle for, you're going to get solicitor and client costs. And it's always been a bone of contention with plaintiffs that their client has to pay part of their costs. Here's a way where you can get your solicitor client costs. The other side of the coin is that if the offer of the defendant is successful and you haven't picked it up, that defendant will get costs on a party-and-party basis from the date of his offer. Now, I frankly think that when this system takes hold, that it will result in an awful lot of settlements, and it's going to mean that lawyers will have to turn their minds to assessing their cases at a much earlier stage if they want to make costs a meaningful issue in the litigation. The transitional section is 1.02, and generally speaking, actions which are now in progress are subject to the rules, or will be when they come in on January the 1st. So, have a pleasant summer.
Thank you, Mallory. Doug Goudie, do you remember the topic that you agreed to deal with?
I remember the topic, but when I said I'd deal with it, and I wasn't going to say anything about this, I thought that I could simply wing it, and then you confirmed my agreement and said, and your paper will be in by the 23rd of May. The reason that the program was changed is that His Lordship thought this topic would be provocative of questions that the panel might better handle after it. The unhappy thought I leave with you is that the subject is provocative, the paper isn't very. It is the fact that until 1983, there was never ever a case in Canada, reported at least, in which an insurer was held liable for damages in excess of its limits. It would be comfortable to think that that was so because of the manner in which insurers and their counsel have dealt with such cases throughout the years. because for the past 30 years, a substantial body of laws developed in the states directly on point. None here. Initially, when I began to think about the paper, I thought it must be that. That is, we've been doing our job, we've been acting in good faith, ergo, no successful action. Reflecting, it may not be that at all. I leave it with you to decide what it has been. Bob Montgomery, as he then was, would vouch for the fact that 25 years ago, when standard auto limits were $5,000 and $10,000, you seldom ever saw a claim in excessive limit, and yet virtually never saw a judgment in excessive limits. When limits went to 10, 20, and on up, you still seldom ever saw a claim in excessive limit, and rarely, if ever, saw a judgment in excessive limits. The problem of the insurer's potential liability just didn't arise. Today, we have minimum limits of $200,000, much higher than they are in most states, and yet today, for the first time, routinely, even in county court actions, you day by day get statements of claim in which damages are sought well in excess of standard limits and not infrequently in excess of excess limits. I'm not sure what the moral is. I was unable to draw one. The fact is we are today, for the first time, as insurers and their counsel, facing a real position between a rock and a hard place, I suppose, in that we are routinely dealing with claims which exceed liability limits. The paper attempts to deal in a very cursory fashion with the development of the law in the states, which it's obvious our courts are prepared to follow, and indeed are now following. And if you'll track through with me, that's briefly what I'll do with you now. Most of us encounter the problem, whether as a plaintiff, solicitor, or defense counsel, in the context of the auto policy. The comments that I make are equally applicable to any liability policy, although it perhaps is a problem that arises most regularly with the bodily injury claim against an insured motorist. That type of policy obliges the insurer to defend the action against its insured and to satisfy a judgment against the insured up to and not beyond, in terms of the explicit term of the policy, the stated limit of the policy. It reserves to the insurer, to the exclusion of the insured, the right to negotiate and to settle. And it's out of that particular arrogation to the insurer of that right that its potential liability in excessive limits arises. Were it not for that, it would be perhaps the usual thing that the insured himself would be out attempting to settle to avoid any theoretical personal exposure. He may not do that, and the fact that he may not do that as a matter of contract is apparently what gives rise to the insurer's exposure, because it creates an immediate and obvious conflict of interest in the event of a claim in excessive limits. If you, the defendant, insured for $200,000, are faced with a claim where there's a risk of judgment of $250,000, clearly you want the case settled for $200,000 or less if that's possible. The insurer, looking at its maximum exposure, might prefer that the case go ahead to judgment, gambling on the possibility that the judgment will not exceed limits, and in any event, being aware of its maximum exposure. In a sense, it has little to lose. And because it's in that position, it has to tread very warily. I think if you want to approach the thing in a simplistic fashion, you can look simply at the 3 cases out of California that are in the material, because they do draw together all of the thinking that seems to me to have gone on in all of the various states south of the border, where really the only jurisprudence exists that will be meaningful to you. The first such case is that of Communale and Traders General, one in which the policy limits were 10 and 20. It confuses the case somewhat, but not for our purposes, that the insurer there denied coverage entirely. They said, you're not entitled to coverage. We're not going to defend up to limits or at all. During the course of the case, it became possible to settle with the plaintiff for $4,000. Traders weren't interested because they said there simply wasn't a policy that they had to respond to. The case went to judgment for a total of $26,250, and the judgment creditor in that case, that is the plaintiff who had succeeded, brought an action, took an assignment of the insured's rights against the insurer, brought an action against the insurer, and it's out of the decision of that court that principles are enunciated that you can see arising throughout every subsequent case. That was a 1958 decision, and the principles, they've been honed a little, but they really haven't changed. And they are 4 in number, and I'll read them. In every contract, including policies of insurance, there is an implied covenant that neither party will do anything to impair the right of the other to receive the benefits of the agreement. Simply put, there is an implicit duty on each party to act in good faith with respect to the other. Nothing in the policy about that. Nowhere in the contract does it say the insurer has a duty to settle. It may, but because it precludes the insured from settling, it has to act in good faith. Secondly, this implied obligation of good faith and fair dealing requires of an insurer that it settle in an appropriate case, although the policy does not by its terms expressly require it. In deciding whether or not to settle, the insurer must give at least as much consideration to the interests of its insured as to its own. You can see through decisions in certain of the courts in the states that has been placed at a higher level. Some cases suggest that the insurer must give the insured's interest prime consideration, put the insured first. And it wouldn't shock me if that were the approach that our courts someday will take, if not immediately. Fourthly, when there is a great risk of a judgment in excess of policy limits, so that the most reasonable disposition is settlement within those limits, good faith and fair dealing require the insurer to settle or be liable for breach of its implied covenant, having reserved to itself control over the litigation and settlement. Whether it need be in the future a great risk or simply a palpable risk or some other description of a risk that will be seen as giving rise, we'll have to wait and see. The measure of damages for that breach of the implied covenant are obviously the exposure the insured has suffered in the judgment in excess of limits, and in the context of his lordship's comments on costs, if it happened because of refusal to accept an offer by the plaintiff to settle that costs on a solicitor-client basis were awarded, obviously I think the insurer would be responsible for those in addition to the amount exceeding the limit. There follows in the material, and again I'll read them quickly, a list of those considerations which ought to be made by the insurer in determining which way to jump in the event of claiming excessive limits. They are at the same time considerations I suggest a court will later make in trying to determine whether the insurer did act in good faith, and they are, by the same token, questions to which you will want an answer from the insurance company in the event you have an action against them in bad faith, because the answers to these questions will determine whether or not the insurer, I think, is likely to be held liable, and they pretty much speak for themselves. There obviously has to be a proper consideration by the insurer and its counsel of the injured claimant's case, both as regards liability and damages. If you don't start with that basis, you're not doing anything in terms of judging the possible outcome of the case. Consideration would be given to attempts by the insurer to induce the insured to contribute to a settlement. in the past, more than it should have happened, insurers have sought to save on their own limits by saying, we've got $100,000, we don't think the case is worth anything like that. You may have some exposure above that limit. We'll throw in 90 if you'll pay 5 out of your pocket, and together we can get rid of it for 95,000. The ultimate in bad faith, I think, and it's certainly a consideration that will be looked at. Failure of the insurer to properly investigate the circumstances so as to ascertain the evidence against the insured. That simply says, I think, that the case has to be properly prepared. And if it weren't in some aspect, that might be evidence on which an insurer's liability could stand. The insurer's rejection of advice of its own attorney or agent. Pretty obviously, if the insurer's own lawyer says, I think we should settle, and we should settle now for this amount of money, that's rejected. The claim goes in excessive limits. It rather sounds like bad faith. The amount of financial risk to which each party is exposed in the event of a refusal to settle, it's almost always the insured who has the exposure. The insurer has a fixed limit that it knows it's on the line for. The insured is the person who may ultimately have to dig into his own pocket. There are duties that apply to the insured. The fault of the insured in inducing the insurer's rejection of the compromise offer by misleading it as to the facts, not a likely circumstance. Did the insurer reject a compromise offer after an excess verdict had been entered? Implicit there is a duty on the insurer after judgment to try and compromise pending appeal, and failing to do so perhaps to attract a liability. Does the insurer have reinsurance as a protection? Can it be somewhat indifferent because of its own reinsured position? Did the insurer make a subjective evaluation of the claimant's witnesses? Again, that's just a matter of was the case properly prepared, I think. Did the insurer favor going to trial because the insured was judgment-proof? And I've heard counsel in Toronto say, I don't have to worry about the claim in excess because my client, the insured, hasn't got any money anyway. That's not a proper consideration. That he might be damnified, whether he can pay it or not, is something obviously that has to be considered. But it wouldn't be the first time that an insurer had made the decision on the basis that it really can't hurt him because he's a pauper. Did the insurer increase its reserves after it rejected a settlement offer? In a case against an insurer after the event, you're going to get production of the insurer's whole file, obviously. And it would look bad, I think, for the insurer and good for you if, notwithstanding they had rejected your offer, they had jacked their reserve up to close to limits, something that you'll obviously want to find out about. Did the insurer establish an arbitrary settlement figure lower than the policy limits? The key word there is arbitrary. If it's an arbitrary decision, it smells of bad faith. Did the insurer have a representative at the trial who increased the settlement offer if the trial went badly? His lordship may have something to say about a case which he recently tried, in which, as I understand it, the insurer wasn't present to cope on a day-to-day basis, and that might be some evidence of bad faith. And any other factors which tend to establish or negate bad faith. I've spoken over and over of good faith, bad faith as being the criterion by which the court will judge the insurer's conduct. And that's true of many of the cases in the states. It can equally be said of many other cases that they take the negligence concept as the basis for liability, and they ask the question whether or not this is a case in which a prudent man with limitless exposure would have settled, would have accepted the offer of settlement. The two have merged because what one court calls bad faith, another will call negligence, and what another court calls negligence, so another will call bad faith. The merger can be seen and has been alluded to in our courts in the case of Chrissy versus Security Insurance Company of New Haven, which is, I suggest, the key case that you should look at because it's the one case referred to which has been paid some judicial credence by our courts. And I won't bore you with the facts, they're set out there. It enunciates the concept that you must look at whether or not this insurer, acting prudently, would have accepted the offer if it had no policy limit at all. In other words, if its ultimate exposure was the moon, how would it have dealt with this settlement offer? And that's the basis on which you will judge its conduct. It was argued in this case, and I've set it out fully in the material, and I'd like to read it to you. An argument put by counsel in favor of a standard of absolute liability. Forget good faith, forget negligence. If the insurer has a $100,000 policy, and if it could have settled within that limit and the judgment goes for more, it's automatically obliged to pay more. And I think it's sufficiently important to read because, as you'll hear from me later, Justice Fitzpatrick, for one, has indicated some predilection toward that approach. It has a certain compelling simplicity. No disrespect to Fitzpatrick, Jay. It runs this way, and I'll read it quickly. Obviously, it will always be in the insured's interest to settle within the policy limits when there is any danger, however slight, of a judgment in excess of those limits. Accordingly, the rejection of a settlement within the limits where there is any danger of a judgment in excess of the limits can be justified, if at all, only on the basis of interests of the insurer. I think that speaks for itself. And in light of the common knowledge that settlement is one of the usual methods by which an insured receives protection under a liability policy, it may not be unreasonable for an insured who purchases a policy with limits to believe that a sum of money equal to the limits of the policy is available and will be used so as to avoid liability on his part with regard to any covered accident. I bought a policy worth $200,000, get out and spend the money. Protect me. That's why I bought the insurance, is really all they're saying. In view of such expectation, an insurer should not be permitted to further its own interests by rejecting opportunities to settle within the policy limits unless it is also willing to absorb losses which may result from its failure to settle. The argument saying essentially, you're the person who stands to win by taking this posture. If you're going to shoot crap, put your money in the middle, and if you lose, it's gone. There is a certain element of fairness to that. God forbid that it becomes the law. The proposed rule is a simple one to apply, I'm still quoting, and avoids the burdens of a determination whether a settlement offer within the policy limits are reasonable. It avoids the nice question of, was there a great risk of judgment? Did the insurer act reasonable? Did it meet all of those standards that I've spoken of earlier? The proposed rule would also eliminate the danger that an insurer faced with a settlement offer at or near policy limits will reject it and gamble with the insured's money, because that's in a sense what it's doing, to further its own interests. Moreover, it's not entirely clear that the proposed rule would place a burden on insurers substantially greater than that which is present under the existing law. The size of the judgment recovered in the personal injury action when it exceeds the policy limits, although not conclusive, furnishes an inference that the value of the claim is equivalent of the amount of the judgment, and that acceptance of an offer within those limits was the reasonable method of dealing with the claim. It will be difficult for an insurer, after the fact, facing a judgment for $150,000, to say that there was no reasonable risk of that result. The fact of the judgment is some evidence of what the case really probably was worth. That particular line of argument in favor of absolute liability was raised again in the third California case to which I refer, the Rova Farm case, but wasn't dealt with specifically because it didn't have to be in that particular case. The Rova case is important, I think, for one other reason. It has been thought by many here, and I've frequently heard it expressed, that the insurer doesn't have to worry about settlement within limits unless the plaintiff offers to settle. If the insurer does, or counsel doesn't receive an offer to settle within limits, he can sit on his hands, safe in the belief that he can't later be responsible for the excess judgment. The Rova case says that's not so, at least in California. The court there and in my belief quite properly, held that there was an affirmative duty on the insurer to explore settlement, to take the bit in its teeth and try to provoke a settlement for an appropriate amount within limits. I would suggest to you that that will be the standard of conduct that our courts require here, although they haven't had to address it yet. With respect to the propriety of the insurer's decision not to settle, the case raises these points, which I think you keep in the back of your mind in terms of how you're going to bring liability home to an insurer in excess. While the view of the insurer or its attorney as to liability is an important factor, a good faith evaluation not to settle requires more. It includes consideration of the anticipated range of a verdict should it be adverse, the strengths and weaknesses of all the evidence to be presented on either side, so far as it's known, history of the particular geographic area, which I think is more significant in the States than here, although maybe you know that North Bay juries are higher than Sudbury juries, and that's a fact you should consider if it is the fact. And the relative appearance, persuasiveness, and likely appeal of the plaintiff. Your material has a typo there. It says of the complaint, and it should read plaintiff, the insured, and the witnesses at the trial. Now, those three cases have been considered peripherally twice by our courts and head-on only once, there having been only 3 cases in Ontario, and I believe it's true of the whole of Canada, in which the liability insurer, the insurer's liability, has been contemplated. The most recent is Caramanolis and Prudential, which is referred to a judgment of Mr. Justice Katzmann, and it deals with the issue whether or not a judgment creditor, that is a successful plaintiff, with a judgment in excess of the defendant's coverage, can maintain an action himself directly against the liability insurer, urging that the insurer acted in bad faith or negligently in not settling with him when they might have short of judgment. And his lordship held there that whatever rights there may be as between insured and insurer arising out of the insurer's conduct, they don't benefit